Good morning, everyone. It is now 9 a.m. sharp. I would like us to kick off with today's meeting. Welcome back to everyone. But before we start with any of the welcomings and apologies, etc., I would just like to ask Babalwa first whether we've got quorum to continue.
Good morning. We do have a quorum.
Thank you, Babalwa. Colleagues, can we move to adopt the agenda as proposed? Honourable Schikkerling.
Good morning, Chairperson, and good morning to all the colleagues online, as well as the staff members from Parliament. We haven't seen each other for a long time. I hereby move for the adoption of the agenda. Thank you very much.
Thank you, Honourable Schikkerling. Can I have a second to that? Honourable Khoza.
No, thank you very much, Chair. Good morning to honourable members. It's been long. We hope you have rested recess as we kick off. To greet everyone once again and also take this opportunity to second the
Thank you very much, Honourable Khoza and Honourable Schikkerling. The agenda is then adopted as is. Babalwa, do we have any apologies for today?
Yes, Chairperson, we do have the apologies. The Minister is requesting to be excused early today at 11 due to another engagement that requires his attention. Mr. Skosana will not be able, he is unavailable until the 21st of August. Honorable Shabana will not be able to attend the meeting. He has a bereavement. Honorable Dereko, she will be attending the meeting of the impeachment committee, and Rev Meshu is requesting to be excused at 11:30 to attend another meeting of the portfolio committee on international relations. Thank you, Chair.
Thank you very much, Babalwa. Yes, the Minister did contact me earlier in the week, and that is 100%. Honourable Khoza, I see your hand is up.
Thank you very much, Chair. On behalf of our member, Honourable Leanne Matthys, she kindly requested me to hand her apologies for today's meeting due to other commitments. Thank you. Can it be recorded as such?
Yes, 100%. Thank you, Honourable Khoza. That is noted and will be recorded as such. Colleagues, today we are meeting for the first meeting after the tabling of the SAPS amendment bill. You would have seen that on the agenda as well. You know, we have here and there through the Civilian Secretariat on Police have touched on the bill before. There have been some presentations done here and there, but since it's been tabled, today is the first official meeting where we will start deliberations and actually receive a detailed presentation from the Secretariat on the said bill. I'm not going to waste time with lots of opening remarks, etc. Today is more of a listening exercise and to ask questions of clarity, etc. This is a bill we've been waiting for a considerable amount of time, and we look forward to the engagement with the Minister of Police, the Deputy Ministers of Police. I'm going to give you an opportunity shortly, as well as the Civilian Secretariat of Police and any other stakeholders that play a role. So with that, before we move to the actual presentation, I would like to invite Acting Minister of Police, Minister Kachalia, to maybe just do a brief introduction. And Minister, if I may then ask you to introduce the team doing the presentation of the Secretariat, and you're welcome to hand the floor to them as well. Then after which we can engage and ask questions. I will give adequate time after the presentation for all the members to ask questions, get clarity, etc. Remember that we've got a continuation of this meeting on Friday, where we will have more opportunities to engage and get questions of clarity. And yeah, so this is a longer process, so please don't feel rushed to try and have to push everything to be mentioned today. Minister Kachalia. Is Minister Kachalia with us? So maybe I can go to Deputy Minister Matale or Deputy Minister Boshielo.
Good morning, Chairperson. A long time not seeing you. And also good morning to all honorable members, Honorable Shigring, Honorable Koza, and everybody. I think now we're back in the game, and I'm happy that we're starting on this good way of making sure that this bill goes on. And also let me greet dear Matali and also our civilian secretariat as led by the DG. Thank you very much, Chairperson.
Thank you very much, DM. Minister Kachalia did send me a message now saying that he's struggling with his link, so he will be with us shortly. And it's not that he's not in attendance. DM Matale, I see you've also made an appearance. It's good to see you and welcome. Would you like to also say something before we commence?
No, I think good morning to you, Chair, and members of the committee, Minister and Deputy Minister Boshielo and Kachalia, DG Sibuyi and the delegation. No, this is an important day for us and for the Portfolio Committee and for Parliament to earnestly start the process to deal with the amendment of the South African Police Service Amendment Bill. An amendment which is necessary. I know along the way, Chair, there have been minor amendments from time to time, and some of them inserted by the Constitutional Court on the constitutionality of some aspects of this legislation. This is a piece of legislation that should have been processed a while. I think it took a very, very long time. When we arrived here, it was on the table, and we did all that was possible for us to arrive here. And I'm grateful to the Secretariat for having steered the ship in this regard, working together with the leadership of the South African Police Service, and commend the Speaker of Parliament, Medidiza, and yourself, Chair, to have put aside time for us to deal with this piece of legislation so that the South African police can work in an environment guided by legislation which is in line with the Constitution which was adopted in 96. It is clear that if you look at then and now, we are dealing with this piece of legislation. It has been a while, and we should commend members and everybody who have made it possible that today we come and appear before you. I think unless if Minister have connected by now, if not, I will suggest that we should allow the Civilian Secretariat to lead. I think he is connected on the platform, Chair. I think I should allow you to allow him to lead us in this regard. But thank you for giving me the opportunity to make my comments this morning as we are about to start with this important piece of legislation. Thanks very much, Chair.
Thank you, DM. So with that, DM allowed me to allow him to allow Minister Kachalia to to make a few brief remarks. Minister Kachalia, I see the link is fixed. You're more than welcome.
Thank you, Chair.
Good morning, Chairperson, and to members of the committee. My apologies. I had a problem with the link, but it looks like it's now been resolved. Let me greet the Deputy Minister, Castle Matale. I'm not sure DM Bushello is on the platform.
Yes, she's on.
DM Bushello, let me greet you. General Dimpane called me last night. She has tendered an apology for departmental work, and I agreed that she should attend to her departmental responsibilities. The presentation today will be led by Mr. Sibui, of the Civilian Secretariat, the DG, and we're also accompanied by General Van Rooyen, representing the police service. And greetings to all the senior officials on the platform and you and the members of the committee. I just came in at the tail end of DM Matale's comments, so let me just make some very brief introductory comments. This legislation has its origins in 2018, so it's around, the project has lasted for around 7 years. And the reason is, at least in part, that it's a comprehensive project, considering many aspects of policing. Some of the legislation, the amendments that are being proposed, are the result of decisions of the Constitutional Court. I think three Constitutional Court decisions which have required these amendments. But the legislation also deals with many issues that have been the subject of political and policy debate in the country for some time, aimed at strengthening the South African Police Service and our fight against crime. So this legislation has many dimensions. The debate and the discussion within the committee is going to be very important. So is the process of public participation, because this is a major piece of legislation. My second introductory observation is this, that this project of reform in some sense has been in the public domain for a period of time. But we are now in a kind of defining moment, resulting from the appointment of the Madlanga Commission and the revelations of the depth of the crisis. In not only in policing, but I think in the criminal justice system. The department has responded by formulating a reset agenda, which is in the process of being finalized, and certainly that will be presented to the committee for engagement as soon as we are ready. It's a complicated undertaking, but we expect to be ready quite soon. Now, the point I want to make is this, that both that reset agenda, which is a response to the current moment, and the recommendations that the Madlanga Commission will make by the end of the year, are going to cast the reform agenda in on a broader canvas, raise questions perhaps that we haven't raised, questions that require reform, including legislative reform. And so even though we're undertaking this important piece of reform by having a Parliament consider this piece of legislation, I do not think that the reform process and the legislative response is at an end point. In fact, I have already received an advisory note, an information note from the National Commissioner with her observations about this legislation, aspects of this legislation, the reset agenda, and what's emerging from the Madlanga moment, which will require further legislative responses. So I make that observation just to indicate that I think the reform agenda, which is being undertaken by the executive together with Parliament, is at an important moment, but it certainly, the work will not have been concluded by the time that we finalize and adopt this legislation. With those observations, Chairperson, and with your permission, I will ask DG Sibuyi to lead the presentation.
Thank you, Minister Kachalia. DG Sibuyi, the floor is yours.
Thank you very much, Chair, and my greetings to yourself, Chair, and the honourable members of the Portfolio Committee on Police, to the Minister, Minister Kachalia, Deputy Ministers, Matale, as well as Dr. Bushielo, DDGs from Civilian Secretariat, as well as the representatives of the National Commissioner, in particular, General Van Rooyen, and all colleagues on the platform. Chair, the minister have and the deputy ministers already alluded to the introductory remark in terms of the purpose of the legislative amendment, over and above in terms of ensuring that the legislation complies with the final constitution of 1996, Act 118 of 1996, and further to effect various court judgments that have declared many or certain provisions that the Constitutional Court had found unconstitutional in various court judgments. But also there were recommendations that came from the Falam Commission relating to the use of force, as well as the regulations of gatherings that we needed to deal with. So in a nutshell, the legislation responds to that in terms of ensuring that it becomes compliant with the Constitution. Chair, having said that, with your permission, we'll flight the presentation now. If the presentation could be flighted, and ask Mr. Mokuzane, who was leading the drafting team, to proceed with the presentation. Mr. Mokuzane, please proceed.
Thank you, DG. Good morning, Honorable Chairperson and honorable members. Good morning as well as to the Minister of Police and Deputy Ministers. Chairperson, I'm going to take you through the presentation. The DG. The DG has already covered the background to the amendments. Through the by permission of the chairperson, I don't know, should I also repeat the background to the amendments, the purpose of the amendments, and I will take the committee straight to clause by clause discussion if the committee permits.
You can guide us. Thank you. I think DG Sabui needs to make the decision as to how we're going to get the most accurate presentation.
Thanks, Chair. You can start from the beginning, Mr. Mukujwana, please, so that we place properly on record to before Parliament the introductory issues in the presentation. Thank you.
Thank you, DG. The presentation, we will have the purpose of the presentation, the background to the amendments, clause by clause discussion, consultations undertaken on the bill, and as well as the recommendations. When coming to the purpose is to brief the committee on the amendments proposed in the South African Police Service Amendment Act that we've tabled. To the background, the review of the SAPS Act was necessary in view of the following. The Act was adopted before Constitution of 1996, and although amendments have been effected to the Principal Act, references to the Constitution, the Principal Act had to be totally aligned to the Constitution, and all references to the interim Constitution in the Act needed to be aligned with the Constitution. Policing in South Africa was based on the principles of National Crime Prevention Strategy of 1996.
Apologies,
DG.
Just apologies for the interruption. There's no presentation on the screen at the moment. I see the hand of the Honourable Meshwe is also up. I assume it's because of that, Honourable Meshwe.
Yes, Chairperson, it's because of that.
Thank you, Honourable Reverend. So apologies for the interruption. DG, can we just fix that, please?
Okay, thank you. We're on it. We're on it, Chair.
No worries. Thank you. Are we winning?
My apologies, Chair. It looks like network is failing us from the boardroom where we are in.
Don't worry, DG. Let's just give 3 minutes. I'm sure
Okay,
everyone
thank you very much. Yes, thank you very much.
will give
Yes.
time. So let's give 3 minutes and then we can continue. No problem. There we go. Thank you, DG.
Thanks a lot, Chair. Please proceed, Silo.
Thank you, DG. My apologies for the technical glitches, Chairperson and members. Starting from the purpose of the presentation, the purpose is to brief the committee on the amendments proposed in the South African Police Service Amendment Bill that we tabled in Parliament. Next slide. The review of the SAPS Act was necessary in view of the following. The Act was adopted before the Constitution of 1996, and although amendments have been effected to the Act with reference to the Constitution, the principal Act had not been totally aligned to the Constitution, and all references to the interim Constitution of 1993 need to be aligned with the current Constitution. Next slide. Policing in South Africa was based in the principles of National Crime Prevention Strategy of 1996, as well as White Paper on Safety and Security of 1998, which were adopted by Cabinet and were both based on the prescripts of the Constitution. A number of policies were adopted since then, namely White Paper on Policing of 2016, White Paper on Safety and Security of 2016, community policing policy, and policy on the single police service, as well as the National Development Plan. The Act, therefore, needs to be aligned with those policies. Next slide. The Constitutional Court judgment of Helen Suzman Foundation versus President and others, and Lenista versus the President and others judgment found certain sections of the Act to be unconstitutional and ordered the deletion of those sections with immediate effect. And the Constitution also confirmed that the DPCI must have adequate independence to fulfill its constitutional and anti-corruption mandate, and declared several provisions of the SAPS Act to be constitutionally invalid. In Mlungwana and others versus the state and other judgment, the Constitutional Court found Section 12, subsection 1, paragraph A of Regulation of Gatherings Act to be unconstitutional. The judgment concerns the right to peaceful assembly under Section 17 of the Constitution, which held that criminalizing the convening of peaceful gatherings of more than 15 people merely because prior notice was not given was unjustifiable limitation of rights to assemble, and declared Section 12(1)(a) of Regulation of Gatherings to be unconstitutional. Next slide. In the judgment of Residents of Industry, House and others versus the Minister of Police, the court found Section 13(7)(c) of the Act to be unconstitutional. The court held that Section 13(7)(c) of the Act, to the extent that it authorized warrantless searches of private homes and persons inside them, was unconstitutional, and because it is unjustifiably infringed constitutional right to privacy. The judgment reinforces police powers to maintain public order and safety must be exercised within constitutional limits, and it cannot permit arbitrary or warrantless intrusion into privacy and dignity of their homes. After the Marikana event, Commission of Inquiry, which was headed by Judge Falam, made recommendations which included appointment of panel of experts to investigate various aspects relating to policing in general and crowd management in particular, and report to the Minister of Police. The Minister has received the report of the panel of experts, and relevant recommendations made by the panel have been included in this bill. And subsequent legislations pertaining to IPIT and CSPS Act, Civilian Secretariat for Police Service, further necessitated amendments to the Principal Act. The bill also proposes community policing forums and community policing boards transferred from South African Police Service to the MECs and the Provincial Secretariat for Police Service. The bill further ensures that legislation does not only provide for funding of projects for CPFs, but also to include activities associated with projects as well as equipment necessary to perform such activities. Coming to the clause by clause discussion of the bill. Clause 1 of the bill amends Section 1 of the Act by proposing substitution, deletion, and insertion of certain definitions. Clause 2 inserts a new chapter 1, capital A, in the Principal Act, which provides for purpose of the Act. Clause 3 substitute the heading of chapter 2 of the Principal Act by substituting ministerial services with national policing policy. Clause 4 repeals sections 2, 3, and 4 of the Act, which provides for the establishment and functions of Secretariat and Executive Coordinating Committee. Clause 5 proposes the insertion of new section 4 capital A to provide for the national policing policy. Clause 6 amends section 5 of the Act by providing for establishment of services as the single national police service referred in section 199 of the Constitution. Clause 7 proposes amendments to section 6 to the Act by substituting heading from the appointment of national and provincial commissioners to appointment of commissioners, and to provide for the appointment of deputy national commissioners by the National Commission. Next slide. Clause 8 proposes to insert new sections 6 capital A to 6 capital E into the Act. These sections will provide for establishment and composition of National Policing Advisory Committee. In addition, the inserted section also provides for the disqualification, removal, resignation of member from NPEC and meetings of NPEC, funding, secretariat, and remuneration of members of NPEC and functions of National Policing Advisory Committee. Section 9, it proposes the amendment to Section 8 to include and provide for steps against the Deputy National Commissioner in the case of loss of confidence in the Deputy National Commissioner by the National Commissioner. During the inquiry, the Deputy National Commissioner's suspension and entitlement to salary, allowance, or benefits will be same as those applicable when Provincial Commissioner is being investigated. Clause 10 proposed to amend Section 9 of the Act to make provisions that apply to National Commissioner and Provincial Commissioners with regard to misconduct and unfitness, also applicable to Deputy National Commissioners. Clause 11 proposes substitution of the Board of Commissioners with Management Forum, which consists of National Commissioner and Provincial Commissioners, and also includes senior members of management of the service as determined from time to time by the National Commissioner. Currently, as it is in Section 10, composition of the Board of Commissioners consists of National Commissioner and Provincial Commissioners only. So we've inserted the provision to also make provision for National Commissioner to determine for senior members to be part of Management Forum. Clause 12 of the bill proposes to amend Section 11 by providing for the control and management of service by National Commissioner in accordance with National Policing Policy and the directions of the Minister. It also inserts subsections 1 capital A to section 1 capital D, which reflect powers of the National Commissioner, allocation of resources by National Commissioner, allocation of budget for province, and directions issued by the Minister to the National Commissioner in terms of Section 207, subsection 2 of the Constitution. The clause further provides how National Commissioner shall deal with report from Secretary for Police Service. Clause 13 proposed amendment to Section 12 by inserting subsection 1 on the expansion of responsibilities of Provincial Commissioner. Clause 14 proposed to amend Section 13 by providing that the use of minimum force by a member should be reasonably necessary and proportionate to the circumstances, and fully automatic weapons may not be used in gatherings or demonstrations. The clause also provides for deployment of members to comply with international obligations, disciplinary measures, and jurisdiction of South African courts, to comply with the Constitutional Court judgment of the residents of industry and others versus the Minister of Police. Section 13(7)(c) of the Act has been amended. Clause 15, substitute the reference in section 15 of Act to the Exchequer Act of 1975 for reference to Public Service Management Act of 1999. It also includes national head of the Directorate for Priority Crime Investigation in the provisions related to authority to delegate powers. Clause 16 proposes amendment to section 15, capital A, to provide for the use of fingerprints for performing a vetting investigation as contemplated in section 2, capital A of the National Strategic Intelligence Act 39 of 1994, and the performance of integrity testing and lifestyle audits referred to in proposed section 28, capital A of the bill. Clause 17 proposes deletion for paragraph I in section 15E of the Act, which provides for the definition of criminal procedure Act of 1977, as clause 1 proposes insertion of the definition of the said in the said Act in section 1 of the Principal Act. Clause 18 provide for the inclusion of municipal police recruits in the requirement to submit DNA samples for purpose of forensic profiles to be included in the elimination index. In clause 19, we're substituting sections 15 capital S subsection 2 to delete the word unlawful. Clause 20 provides for the additional items on which the minister may make regulations. Clause 21 proposed to amend section 16 of the Act by substituting all references to Directorate for Priority Crime Investigation with Directorate in accordance with the proposed definition of Directorate in clause 1 of the bill. Clause 22 substitute the National Public Order Policing Unit with the National Public Order Policing Capacity. The National Public Order Policing Capacity deployed in a province shall operate under the National Command and Control. National Commissioner may approve the deployment of the National Public Order Capacity in circumstances where Provincial Commissioner is unable to maintain public order and the deployment of National Public Order Policing Capacity is necessary to restore public order. It further provides that the National Commissioner must report to Parliament and shall copy the Civilian Secretariat and IPIT on quarterly basis on the details listed in subsection 8. Clause 23 proposes to amend section 17 capital A of the Act by the deletion of definition of Directorate as it is already defined in clause 1 of the bill. Clause 24 proposes the addition of subsections 4, 5 to section 17C to ensure cooperative approach between National Commissioner and National Head of Directorate in drafting national instructions, taking into account particular circumstances of the Directorate. In clause 25, we propose to include academic qualification in section 17 capital CA as a factor which must be considered by the minister in appointment of national head, deputy national head, and provincial head of the Directorate. The clause also proposes to delete subsections 15 and 16 in line with the Helen Suzman judgment. The clause also proposes the insertion of subsection 13 capital A in section 17CA of the Act to provide legal certainty for fact that the national head of the DPCI will be regarded as retired at the expiry of his or her term. Clause 26 proposes amendment to section 17 capital D of the Act in compliance with the Helen Suzman judgment. Clause 27 also complies with Helen Suzman judgment by amending section 17 DA subsection 1. Clause 28 amends section 17 capital A of the Act by substituting the reference to head of the Directorate with national head of Directorate and provides for consequences of members' security clearance being degraded, withdrawn, or refused. In clause 29, subsections 2-3 of section 17F of the Principal Act, and includes that national head of directorate may request a service arrangement regarding performance of service of personnel from any other government department or government institution, as opposed to secondments that are currently provided for. In clause 30, we propose amendments of section 17J to the Act, which proposes the substitution of the reference to Crime Intelligence Division of the Service for reference to the Intelligence Division of the Service, judge, who will be responsible for administrative, financial, and clerical functions. It also provides that the retired judge shall report the outcome of any investigation undertaken by him or her, or any referral to the minister. Clause 33 inserts new chapter 6 capital B and chapter 6 capital C. Chapter 6 capital B provides for the establishment of specialized units, and chapter 6 capital C provides for the establishment of intelligence division of the police service without overlap of intelligence mandates between civilian intelligence and police service intelligence. The clause further provides for the determination of security classification of members and employees of the divisional commissioners and the discharge of members in respect of whom security clearance had been degraded, withdrawn, or refused. In clause 34, we substitute the heading to chapter 7 of the Principal Act with the following heading: Community Policing Forums and Boards. Clause 35 proposed to amend section 18 by providing that the members designated by the station commander, district commanders, and provincial commissioners shall be ex officio members of the Community Policing Forum, Sub-Forum, and Board established at the police station concerned. Clause 36 proposes the repeal of sections 19 to section 23 of the Act. These sections are contained in chapter 7, which deals with community policing forums and boards. As the contents of the said provisions find more application in the civilian secretariat and in the bail. So we propose the insertion of chapter 2 capital A into the civilian secretariat for police service to provide for these sections on the establishment dealing with the CPFs and community policing boards. Clause 37 proposed to amend section 24 by empowering the minister to make regulations to supplement, where required, the provisions of the Compensation for Occupational Injuries and Diseases Act of 1993 in respect of injuries, diseases sustained or contracted by members in the course of their employment or death as a result of such injury or disease. Clause 38 substitutes section 27 to align with section 195 of the Constitution. Clause 39 amends section 28 of the Act by providing that all posts in the service shall be filled with a transparent, competitive, and merit-based process to ensure the best suited person is appointed. In clause 40, the bill proposes the insertion of sections 28A, 28B, and 28C in the Act to provide for integrity testing for recruits and lifestyle audits in respect of all members, as well as taking and keeping of fingerprints of members on a personnel database. Clause 41 repeals section 29, which was originally provided for in terms of the Principal Act for facilitating the rationalization of different police organizations that existed during the transition and their integration into the single national police service. So section 29 no longer serves legitimate purpose, hence it should be deleted. Clause 42 amends section 32 by providing that the National Commissioner in respect of members of the service and the National Head of the Directorate in respect of members of the Directorate to determine the criteria for education, training, and development that such members must undergo. In addition, the National Commissioner shall determine criteria for education, training, and deployment of police trainees and lateral appointees. Clause 43 amends section 33 of the Act to provide that in addition to deed of commission, an appointment certificate which is issued by the National Commissioner or President's minute bearing the signature of both the Minister and the President is proof of appointment as commissioned officer. It further provides that the commission and rank of the commissioned officer shall terminate and be deemed to be cancelled upon the removal of office of the National Commissioner, Deputy National Commissioner, Provincial or Divisional Commissioner, or the National Head of Directorate on the basis of misconduct. Clause 44 amends section 34 to provide for the consequences of member being absent from official duties without the permission of his or her commander for a period exceeding 1 calendar month. Clause 45 amend section 35 of the Act by substituting the reference to Government Service Pension Act of 1973 for reference to Government Employees Pension Law of 1996. Clause 46 proposes to amend section 36 by adding subsection 7, which provides that an application by a member to the National Commission for reinstatement must be considered and finalized within 60 days of the date upon which such application was received by National Commissioner. Clause 47 repeal section 37 of the Act, as police trainees are not appointed as members of the service during the period of basic training, and there is thus no need for discharge of such trainees should they fail to successfully complete their basic training. In clause 48, the bill proposes to substitute section 40 by providing for establishment of disciplinary system by both the National Commissioner of the Service and National Head for the Directorate respectively, that involves dedicated, properly qualified and trained units to perform functions related to presiding officers and disciplinary officers. Clause 49 proposed to amend section 45 by deleting reference to section 212 of the interim constitution and by also deleting subsection 10. Clause 50 amends section 49 subsection 1 by aligning it with the relevant sections of the constitution. Clause 51 substitutes section 60 to provide that property of the service may only be seized or attached in consequence of judgment or order of court of law. Clause 52 substitutes section 63 to delete reference to sections 215, 218, and 219 of Constitution of 1993. Clause 53 amend section 64A subsection 3 by adding paragraph D, which adds to requirements that must be met before MEC may approve an application for establishment of municipal police service, and provides that member of the Executive Council must consider the feasibility of establishing municipal police service. Decision must be taken in consultation with National Commissioner, and should the National Commissioner and the MEC be able to to unable to agree on application for establishment of municipal police service, minister shall mediate between the parties. Clause 54 proposed to amend section 64B by substituting reference to chief executive officers for reference to municipal manager. Clause 55 amend section 64C by substituting reference to executive head of municipal police service for chief of the municipal police service, and providing that chief of municipal police service shall liaise with provincial commissioner in order to ensure coordination of operational activities. In clause 56, the bill proposes substitution of section 64D to provide that when municipal police service is established, municipal council, after consulting with national commissioner, shall appoint fit and proper person as chief of the relevant municipal police service. Clause 57 propose the amendment of section 64E by adding paragraph D on the functions of municipal police service as first responders in enforcement of regulation of gatherings in consultation with local station commander. Clause 58 proposes the insertion of section 64E capital A into the Act, providing for the establishment of public order policing capacity for municipal police service. Clause 59 proposed to amend section 64K to insert subsection 1 capital A, which provides for appointment of National Policing Coordinating Committee by the National Commissioner, and subsection 1B, which provides how the National Policing Coordinating Committee will be constituted. The clause further amends section 64K, subsection 2, providing that the National Commissioner or the person designated by him or her shall act as a chairperson at the meeting of the National Policing Coordinating Committee. Clause 60 proposes amendment of section 64 capital L by substituting the reference to Road Traffic Act of 1989 for reference to National Road Traffic Act of 1996. Clause further provides that where municipal police service failed to maintain national standards, National Commissioner shall issue notice of non-compliance to relevant Metropolitan Council. Clause 61 rectify the numbering of the subparagraphs in section 64M subsection 2 of the Act, and substitute the reference to Minister for Provincial Affairs and Constitutional Development for reference to Minister responsible for cooperative governance and traditional affairs. In clause 62, the bill proposes to amend section 64O of the Act to provide that reasonable steps must be taken by municipal police service to ensure compliance to any provisions of the Principal Act that the minister prescribed that should also apply to municipal police service. Clause 63 amends section 65 to provide for penalty of imprisonment for a period of 5 years as opposed to a period of 12 months for receipt or possession of certain property. Clause 64 provides for the insertion of section 65A in the Principal Act, which provides for new offense relating to disposal or abuse of property or equipment of the service, including uniforms, blue lights, radios, electronic equipment, and medals. Clause 65 amends section 66 by substituting the 6-month period of imprisonment for a period of 5 years. If a person is convicted for wearing a uniform, distinctive badge, baton, when he or she was not entitled to do so. The clause further proposes the addition of subsection 3, which provides that when any jurisdict person which, after having been ordered to refrain from using insignia, emblem, title, or symbol, whether or on a uniform, vehicle, or otherwise, which may be confused with that use of service, fails to comply with such order is guilty of an offense and is convicted and liable to a fine of 100,000. Clause 66 proposes amendment to section 67 to provide for a sentence of imprisonment not exceeding 24 months as opposed to 12 months in respect of offense referred to in subsection 1. In clause 67, the bill proposes to amend section 68 of the Act to substitute 6 months period of imprisonment in respect of offenses referred to in subsections 2 and 3 for a period of 5 years. The clause further proposes addition of subsection 4, providing that any member or employee of the service who uses state vehicle to facilitate, commit, or assist in the commission of crime, amongst other instances, is guilty of offense and liable upon conviction to a fine or to imprisonment for a period not exceeding 10 years. In addition, it proposes addition of subsection 5, which provides that any person who is not a police official, municipal police official, military police official, a member of the South African National Defence Force, or traffic official who his or her position in vehicle fitted with lamp emitting blue light to be guilty of an offense and liable upon conviction to a fine, imprisonment for a period not exceeding 5 years. Clause 68 substitutes section 70 to include in addition to a member of the service, any person employed by the service or reservist who willfully discloses information, including pending investigation, in order to warn suspect or possible suspect of such investigation or imminent arrest regarding planned actions or operations of the service, in order to forewarn any person who may be affected by such action or operation, is to be guilty of an offense and liable upon conviction to a fine or imprisonment for period not exceeding 10 years. Clause 69 proposes to insert new sections 71 capital A and 71 capital B. Section 71 will provide for offenses in respect of knowingly making false reports to the service, spreading untruthful information, or publishing information or hoaxes, causing a diversion and unnecessary use of resources in order to facilitate commission of crime. And 71B prohibits member of the service from conducting an investigation, assisting with the investigation if there is a financial or other interest in investigation which may preclude member exercising or performing powers in the objective manner.
Thank you, Chair, and members of the committee, as well as the Minister and Deputy Ministers. This is our presentation. I can hand back to you, Minister.
Thank you, Mr. Sibui. Let me hand over to the chairperson to conduct the meeting further. Thank you.
Thank you very much, DG. Thank you, Acting Minister Katralia, and thank you for the presentation. I'm immediately going to give an opportunity to the relevant persons to ask questions and to possibly comment. May I see a show of hands? I've already noted the hand of the Honourable Kola Barnard, also the Honourable Mokoena, Honourable Meshwe, Schikkeling, and Mwela. Honourable Kola Barnard, as per usual, I'm going to give 5 minutes, and you're welcome to begin.
Thank you very much, Chair. Yeah, a couple of issues I would like to raise. Just have a look here first. Is it all right to leave this off, the camera off? I don't think we need it on.
Yeah, sure.
Yeah, it's just extraordinary to me that this has taken so long to get here, to come before us, as it were. I mean, we're heading on a decade, aren't we? In terms of bringing this back to Parliament to try and fix was actually a very shameful period in the life of this committee. And it's almost conceivable that these amendments from 3 Concord decisions, we're thinking Glenister, Sussman and the like, invalidating various sections of the SAPS Act, declaring it invalid. It granted police arguably unfettered apartheid era powers to, for example, search private dwellings and such. It's all been outlined. So it was all disproportionate in terms of privacy and dignity. And yeah, it has taken so long to get here. But I still have concerns about what happens once it goes through. First of all, could we please see the socio-economic system report relating to the proposed changes? I don't believe that's been tabled. And while I agree completely with taking the buccal samples from all those in any way linked to the SAPS, I think we have to consider that there are massive laboratory backlogs at the Police Service Forensic Lab, which process the buccal swabs from, for example, the prisoners, with backlogs of hundreds of thousands. Now, surely the system has already broken down. So taking such samples from SAPS members they may well retire before the sample is even entered into the system. So it seems that passing new clauses like this, as well-meaning as they are, seem to be unimplementable. Is that not counterproductive? I don't know where this is going, because you can pass lovely new sections, but if it's impossible to implement them, why are we doing it? And something that really stood out for me was clause 67, and it's increased imprisonment from 12 months to 5 years for the wearing of a SAPS uniform. But it says for a period of 5 years. Now, I'm not sure if some well-meaning magistrate could drop that down, but I think it should say a minimum, because we all know people wearing SAPS uniforms, we know exactly what they're doing, and people who've been held up by these fake blue light vehicles, etc., have been the victims of these countless times. So I think that is just one of the many issues that need to be reconsidered. Thank you, Chair.
Thank you very much, Honourable Kola Barnard. I then go to the Honourable Mokoena.
Thank you very much, Chair, and greetings to your good self, Minister, DMs, honourable members, and delegation from CSP. Let me take this opportunity and welcome the presentation of the amendment bill. Chair, I do have some few questions. The bill indicates that one of the triggers for lifestyle audit is based on suspicion if a person is living beyond their means, which is a very vague standard. And noting that lifestyle audit require extensive access to personal financial information, how does the department believe this provision comply with Section 14 of the Constitution, Section 10, Section 33? And what legal advice was received for this particular provision? And what constitutes reasonable grounds for suspecting that a member is living beyond his or her means? And how are they going to prevent, how are how is it going to prevent this provision from being abused and used to victimize certain members? And then on NPEC, I just want to check that does the establishment of this committee not interfere with the HR functions of recruitment and selection and promotion that is already regulated in the SAPS employment regulations? And what is the purpose of establishing a statutory committee rather than amend the employment regulation? And why are existing recruitment and promotion regulations considered inadequate? And lastly, which NPEC functions are not already performed under the SAPS employment regulation? Thank you very much.
Thank you very much, Honourable Mokoena. Honourable Reverend Meshwe.
Thank you, Mr. Chairman, and greetings to you, sir, to the Honorable Minister, Deputy Ministers, and all members. It has been a while that we were together. My first remark is to state my disappointment that it has taken so many years to respond to the Constitutional Court orders, among others. It is disappointing that the department was willing for years to continue functioning while they know that they are not aligned, that the Constitution is still not the principal law in the country because of the way they were almost ignoring the orders that were given by the Constitutional Court. So I would like to know why it has taken so long for the department to comply with the orders of the Constitutional Court. Second question has to do with the use of automatic rifles during demonstrations. Now, we have been told on numerous occasions that the people involved in illegal mining are heavily armed. And in some instances, we're told that some of them have automatic rifles. So my question is, what will the police be expected to do when they're confronted by people armed with automatic rifles? Because we have been informed that they definitely have them. So I would want to know, in such a case, what will the police do, because they can't match illegal miners or criminals that have automatic rifles? Who will, on their feet at that moment, change the rule, the law, or can there be an exception included in that section so that the police who are fighting, who are dealing with such demonstrators, can be able to defend themselves appropriately? And clause 36 proposes the repeal of 5 sections, section 19, 20, 21, 22, 23 of the Principal Act. I would like to know what was the rationale in the beginning, particularly if in the department there can be individuals who were there when those sections were included in the Principal Act. What is the rationale? Can we go through or can we be taken through those sections and to be told this section, because of 1, 2, 3, is being repealed? Because the people who put them in must have seen the importance of them assisting their service. So I would like to know, and I would appreciate if we can be taken through those sections so that we can have a proper understanding why 5 sections have to be repealed. Thank you, Mr. Chairperson. And then the last one has to do with the integrity testings. Can we get more clarification on that? What do we mean by integrity testings, and how will those testings be done and by whom? Thank you, Chairperson.
Thank you very much, Honourable Reverend Meshwe. The Honourable Schikkerling.
Thank you very much, Chairperson. Hello, good afternoon, good morning, good afternoon, good morning, everyone. I'm a bit late already. Colleagues, Clause 57 and 58 specifically expand the functions of municipal police by allowing them to perform public order policing. Section 206, in bracket 7 of the Constitution expressly allows national legislation to determine the powers and functions of municipal police services. So what is the specific legal or constitutional reason why this bill expands public order powers but stops short of allowing suitably trained metro police officers to investigate crime? If there is no constitutional barrier, why has it been excluded? And then, Chair, Clause 59 creates a National Policing Coordinating Committee, while clauses 60 and 62 strengthen national standards and compliance requirements for municipal police services. If the concern about investigative powers is training, standards, or accountability, why can exactly this framework not be used to accredit capable municipal police services to conduct defined criminal investigations subject to national standards, proper docket management, IPID oversight, and the normal prosecutorial authority of the NPA? A traffic officer can arrest a suspect, secure evidence to an extent, and identify criminal activity, but the investigation must then be handed over to the already overstretched SAPS, and we know that they are very overstretched. Did the Secretariat assess this handover problem when drafting the bill, and what evidence was used to conclude that investigative powers should remain exclusively with the SAPS? And Chair, just to close off then, I heard that Reverend Meshwe asked a question about accountability. And I see that there's various accountability measures within this act, but nowhere does it actually tell us how it's going to be done. And we know about the lifestyle audits that should be taking place, but nowhere does it say that every senior officer will undergo periodic integrity testing, including the National Commissioner and the Deputy National Commissioner, and what action will follow if unexplained wealth is identified, because I think this is something that's very much coming out in the Madlanga Commission. Thank you very much, Chairperson. Thank you.
Thank you very much, Honourable Schikkerling. The Honourable Muela.
Chair, thank you very much, and let me welcome the presentation from the Ministry and start by acknowledging the fact that the bill is indeed a watershed bill that seeks to address issues which were raised, most particularly from the stakeholders and the people of South Africa in particular, to indicate that the bill, the SAPS Act 68 of 1995, had a lot of loopholes and it was an outdated bill. So we are very much happy with the response that the bill is trying to respond to the issues that are currently happening in the country, affecting the people and most particularly remote people who are affected by crime on every day and on their daily basis. So this particular bill seeks to address most of those issues, which I believe were of a great concern to us as South Africans. We can see, Chair, through the commissions that are happening, that most of the police were living beyond their means in terms of the lifestyle audit. So this compulsory lifestyle audit to all senior members and all the officials of the SAPS, it will come in handy to address this particular issue. That is a thorn to policing. And we also comment that the seeking of replacement of the Board of Commissioners with the new management forum, it will also assist because the public have been having a cry that the current recruitment processes that are being done in policing are not that much open and transparent. So this particular forum will assist in ensuring and restoring confidence for the people of South Africa. So we are very happy that this bill is here to respond to the issues that were raised. I just want to raise just few questions with regard to the board. What does the bill allow the National Commissioner to determine additional membership rather than prescribing the composition in legislation? Why does this bill not set out the management forum's functions in greater detail? Would it not be preferable for the Act to prescribe minimum functions, composition, reporting duties, and meeting requirements as required by the proposed bill? And apart from that, Chair, I think the bill will respond to most of the issues that have not been responded before by the previous bill, and also the issue of mandatory from other entities of policing like civil secretariat and IPT, which were also a concern that most of their issues that they are raising uh, were actually not being obliged by the policing. They don't actually take the recommendation into consideration. So mandatory implementation of responses which come from entities must also be taken into consideration so that there is synergy in terms of how the matters of policing should outgo. And that will be very much helpful so that the entities can also see that the work that they are doing is taken into consideration, the advices that are given to policing for implementation, and the outcomes that they have done in terms of their own investigation on the side are taken into consideration so that they can be implemented and resolve the issue of policing in South Africa, fight crime, combat crime, and also put the people of South Africa safe so that the integrity of the policing and restoring confidence of the people of South Africa can as well be restored again. Thank you very much, Chair.
Thank you very much, Honourable Muela. The Honourable Shongwe.
Greetings, Chair. Greetings to the colleagues, members of Parliament, and the officials. Thank you for the opportunity, Chair. Chair, I've been covered by most of the members in most of the topics that I wanted to touch. Especially the Metropolis and the police, because the powers there, Metropolis only arrest most of the time and they never investigate. And most of the time in our communities, Metro is the one that is more visible than the police. So I'm covered by the honorable member who just touched on that matter. I would like to emphasize the training of the Metros because it will really help us in our communities since crime is
Sorry, Honourable Shongwe. Just repeat your last two sentences. Your audio just faded.
Oh, sorry for that. I was disturbed by a call in this. I'm logged into your phone. Sorry for that. But I'm saying I'm largely covered by the member who spoke about the Metro and the police, the difference between the two, because in most of our communities, Metro is the more visible than the SAPS. I think at some stage that clause need to be transversed seriously because Metro is more visible than SAPS in our townships. So training should be given and some powers of also investigating. But keeping in mind that even if we give them training to understand investigating as metros, again, we will have a problem in the justice system where all the investigations done by police and metros will be flowing into one space again, prosecution or justice. Again, cases will get stuck there and all those issues. We have a serious problem. But now my main problem that I want to speak to is the integrity. integrity and implementation is my problem in talking to this bill, because SAPS as a department has a tendency of not implementing the constitution and running with some of the constitution that the laws that are there. It worries me that we might be even wasting time talking about this, trying to amend this bill. For one, Honorable Reverend Misha speaks to, it's embarrassing that it has taken so long for us to get here, especially the department. Let me make an example that is current. General Dimbani, there is I think if I'm not wrong, something that is trending on me that she's not adhering to what the court has said about General Kumalo, that she is blocking the coming back of General Kumalo in the SAPS. The funniest thing ever is that it bears evidence that the department has a problem of implementing what is in the laws. Two, we must, as Parliament, take accountability that speedily moving with times. This act has been there, it's very long, it's very old, I mean to say, it's very old bill that has been there, but it's not in line with our times in how we live now. So we as Parliament has to do things in a pace that is current, in a pace that helps our communities to feel safe with our laws of security. Why am I saying that? In most of the cases, you find that you have a digital, maybe should I put it like that, a digital issue. But when you go to court in our constitution, that thing is not in line with what is happening currently. It's very old.
Very Honourable Shongwe, your audio has suddenly faded again.
Can you hear me now?
Yes, there we go. Perfect.
Yes. I'm saying we as Parliament have to also speedily run things and fix and amend these bills, and also actually be fair to our people, give service delivery in a way that we change these bills in time, because some of them, they are not even for IR. They are long, they are very, very old. They are not in times with our living times. So those are my problems, Chair. But mainly this one of integrity. I am seriously worried about integrity. When we speak integrity, I don't know how they got to that one. I wish to be further explained in this integrity one. What do they mean? What do they mean exactly in the integrity? Because as we sit now in the ad hoc, we spoke in length about this integrity, the credibility of SAPS. Oh, there's timer. I forgot there's timer here. I forgot. Sorry for that. Let me land, Chair.
No problem. I'll give you another 30 seconds.
Thank you, Chair. The importance of us understanding how it is important to implement such bills in time and respect the laws that are given by court is very, very important. I would seriously like to understand and be answered, especially by the Minister of Police, which will the police, even if we change these bills, will they adhere to it? If they fail to adhere to a simple court ruling that General Kumalo must come back to work and work. We had to stop it. There was an arrest that was stopped. Chair, okay, let me respect your time, Chair. Let me respect your time. I'll come back.
Thanks, Honourable Shongwe. Honourable Koza.
No, thank you very much, Chair. Greetings to the Minister, Deputy Ministers, and the DG and the team, honorable members. No, Chair, we appreciate the contribution from other members who also have covered us in as far as a lot of issues with regards to the presentation were concerned. Chair, we also want to highlight that we share the same sentiments that were raised by members in their early opening. That we note with great disappointment, Chair, the significant delay in fulfilling the constitutional obligation to amend the South African Police Service Act. After going through the presentation, we note that the presentation indicates that the principal act has long been misaligned with the Constitution and subsequent legislation and several constitutional court judgments, which our consent, Chair, therefore brings to a lot of questions such as what caused the department to delay this amendment for such an extended period despite being aware of the constitutional deficiencies and legislative misalignments. I think one needs to take us into confidence as to what could have been the delay and to whose interest. And why did the department continue to administer provisions that had been already been identified as inconsistent with the Constitution, instead of prioritizing urgent legislative reforms? This has been a growing concern, and it has brought about a lot of implications, Chair, in the period under review or in the period in which such actions were not taken. And lastly, to that, Chair, we also want to understand as to what practical impact did this delay have on policing, constitutional compliance, public confidence, and the administration of justice. What measures has the department put in place to ensure that future constitutional court judgment requiring legislative amendment are implemented without unnecessary delays? I think, Chair, this must be a serious matter which we need to take into cognizance, and the department ought to respond to that. Chair, I'll just go through a few clauses which I think they were not touched or highlighted into greater perspective. Clause 8, Chair, it speaks of the National Policing Advisory Committee. Chair, I want to understand as to what criteria will be used to appoint members of the NPAC. And second to that, how will SAPS ensure the committee remains independent and not politically influenced? Thirdly, will the NPAC's advice be a binding or merely advisory? And fourthly, what accountability measures will exist if the National Commissioner ignores its recommendation? And my recommendation to that also, Chair, is that the bill should prescribe minimum qualifications, secure clearance requirements, conflict of interest provisions, and require the NPAC to table an annual report in Parliament to strengthen transparency and accountability. I think that if that can be noted, Chair, it can greatly assist. Lastly, Chair, clause 14, just to highlight that it speaks of the use of force and public order policing. We have noted a lot of casualties in the process of crowd management and riot acts. So, Chair, I want to understand as to how will SAPS define minimum force and proportional force in operational practice? And two, what specialized training will public order officers receive? Because in as far as we understand now, it is really not what we expect them to have been equipped of in terms of dealing with such crowd management. And then thirdly, will body-worn cameras be introduced during crowd management operations? My last 30 minutes, Chair, if you may permit.
30 seconds, not 30 minutes, Honorable Koza.
30 seconds, Chair. Therefore, Chair, I just wanted to conclude by saying, okay, yes, Chair, I just want to conclude by saying the bill should require mandatory operational guidelines, regular public reporting on use of force in incidents, enhanced crowd management training, and independent reviews of serious incidents to strengthen public confidence. Thank you very much, Chair.
Thank you very much, Honorable Koza. Before I hand over to DG Sibui and the Minister for that matter, if you would like to assist in answering the questions, I've got one question myself that I would just like to ask. With regards to the issue around, I see the hand of the Honourable Kolobana that went up. I'm going to come to you now. With regards to the issue of integrity management, I just want to know, in terms of the bill, has the Secretariat considered making clear integrity vetting a mandatory prerequisite before any officer is promoted? So, as an example, something like lifestyle audit, that vetting process. So should any senior appointment be allowed to proceed, whether the candidate has not undergone a satisfactory lifestyle audit, has unresolved adverse integrity findings, or has outstanding serious criminal or disciplinary matters? With that, I'm particularly interested in whether the legislation should require any independent verification of lifestyle and financial risk findings, potentially involving bodies like the SIU or anyone else that's appropriate, before appointments at senior level are finalized. And then to just further that question, we repeatedly speak about restoring public confidence in SAPS, but we can't achieve that if the system can promote people into positions of enormous authority while serious questions about their integrity remain unresolved. So what concrete integrity threshold does this bill establish before someone can enter senior management? I think a practical example that we've seen is, for example, promotions that are made or people are put into positions without security clearance. And often then and that's just one type of example, but then the explanation that's given is that, there's a bottleneck with the SSA. So I think this bill presents an opportunity for us to potentially clear that or find an alternative to at least parts of the vetting process. And I'm particularly interested with regards to the lifestyle audit part. And I know that you shouldn't be able to be shortlisted, from what I understand, if you've got other cases against you or open criminal or disciplinary investigations. But it doesn't seem to be foolproof. From what I understand, that has continued to happen. For a quick addition, before I hand over, I note the hand of the Honourable Kolobana. Honourable Kolobana.
Yeah, thank you, Chair. I know that the Act says already that if a SAPS member refuses to undergo integrity testing or lifestyle audits, they will face severe disciplinary consequences. But there is a history of top police simply ignoring the demands, for example, to do security clearance. They just ignore them. They don't go, they don't do it, they won't do it, they just walk away. And nothing has ever been done. It just simply hasn't happened that anything has been done. And so I'd like to know what possible assurance would there be given that this is going to make a difference. Of course, we should have integrity and lifestyle audits. I mean, it's a no-brainer. But if they're not forcefully implemented, I mean, the punishments are detailed there, but no one ever goes through it. So that is something I would want absolute assurance about. And my last 30 seconds that everyone else seems to get. Equally, promotions have frequently been made, and only then does the station commander start doing the various courses they're supposed to have done before they got promoted. Frequently, they fail them. So when will that be dealt with prior to the promotions? Thank you, Chair.
Thank you, Honourable Kolobana. Honourable Schikkerling.
Thank you, Chair. I just have an additional question. Has the Secretariat considered whether the legislation could allow properly trained and accredited law enforcement officers, such as provincial or municipal traffic officers, to take buccal samples from qualifying Schedule 8 arrestees and submit them for processing under the National Forensic DNA System? If the appropriate training, chain of custody, and safeguards are in place, this could absolutely relieve pressure on the SAPS while also helping to expand the National Forensic DNA database more efficiently. If this has been considered and rejected, what is the legal or operational reason? Thank you very much.
Thank you, Honourable Shikeling. I'm going to hand over to Acting Minister Kachalia to facilitate response. Minister.
Thank you, Chairperson, and thank you to the members for the questions. I will make some general observations in response to the questions and then hand over to Mr. Sibui for more specific responses. Honourable members, let me first deal with the question about the delay, or what is perceived as a delay. I understand that this project started when the minister was Bheki Cele. So yes, it has taken a long time. But bear in mind that this is an omnibus bill. It deals with many different matters, from public order policing to the establishment of a board, to integrity vetting. It is an attempt at comprehensive reform, which is inherently complex because there are existing multiple policy documents, commissions of inquiry, the Farlam Commission, the panel of experts, 3 constitutional court judgments, which deal with very different matters. I think that needs to be appreciated because the task of the committee in dealing with this bill, improving it where possible, is to deal with the range of matters that the bill tries to deal with. I wondered when I read the bill whether it might have been better to respond to each court's judgment with proposed amendments to the underlying act. In other words, to approach this task of comprehensive reform on a piecemeal basis. Would that have been the more rational path? Would we have achieved a legislative outcome which was more coherent, rational, and comprehensive had we responded, has the department responded to each commission report, to each commission of inquiry that raised very, very different matters? Now, still, it might be that the question about the time delay is a legitimate one. But is that really the most important question before the committee today, where it has to deal with this piece of comprehensive amendment legislation in this, let's call it the Madlanga moment, which calls out for reform? Should the focus not be with respect on the substantive merit or otherwise of the proposed legislative amendments? I think the reform project in the South African Police Service is too important. And the committee has a responsibility to ensure that the reform project is anchored in a clear, coherent, and rational legislative framework that is capable of implementation. That's the question we all face today. And in that respect, I consider that the committee to be a partner in this process. The committee itself is going to take the time, I assume, to ensure that the outcome is one that has broad public support and that the legislation that is the outcome of this committee process is quality legislation. You will take the time. I've been advised that it can take up to 18 months for Parliament to finalize legislation, especially complex legislation of this kind. The second preliminary point I want to make is that I think the committee has to be clear in a reform process what the purpose of reform legislation is, what legislation can do, what it can't do. So there is a clear distinction to be made between what is required in legislation, which is to authorize, give a legal basis for the reform agenda, but it does not and should not in detail, because in that way we will emerge with legislation that is not workable, legislation that is then able to be implemented. So many of the important questions about the forensic laboratories, for instance, that needs to be dealt with in the implementation stage, because it's about capacity, about resource allocation, and so forth. But there are other matters that members have raised, for instance, with respect to lifestyle audits, integrity testing, the point made by Member Mokoena, also the chairperson, with respect to whether the current provisions relating to these critical matters are specific enough. So whether an amendment to this legislation should be proposed in the committee to strengthen the legal basis for the action that needs to be taken after the legislation has been adopted, enacted, because it's then the responsibility of the ministry under the oversight of the committee to ensure that the reform agenda is properly implemented and executed. But at this point, there will be no guarantee that the legislation itself is sufficient to guarantee a successful, multi-layered, comprehensive reform of the policing service. Now, so what can we do in the legislation? What must this legislation do in order to facilitate and authorize the comprehensive reform in the critical areas that are probably clear to all of us, because I think there is an emerging consensus on what needs to be done. So to Diane Kolobana's point about the forensic labs and the backlogs, clearly a critical question. I'm meeting with the DNA board for the second time tomorrow. Clearly, getting the forensic capacity right must be part of the reset agenda. But so the question for the committee will be, does the legislation do what legislation should do in respect to this particular point? Member Meshwe also raised the issue of integrity testing. Member Mokoena, the chairperson, a few other members. There, I think we must look at the legal provisions. They shouldn't be open. They shouldn't be too discretionary. I think the intuition that they should be more specific is probably right. Now, on the question of municipal policing, This is also a position, a strong position that the provincial government in the Western Cape has taken, led by the Democratic Alliance. I've had representations from the mayor, and I can understand that from the DA's point of view, it's very important to make public statements on this matter. In response to those representations, I have obtained legal advice that the specific recommendations that have been made are not consistent with Section 205 of the Constitution. Nevertheless, I have said that I have an open mind on this matter, that I understand the rationale, because I noticed that it was both Member Schnickeling and Honourable Member Koza of a very different political party who also raised this matter. Now, the question is, can we build a cross-party consensus on whether municipal police should also have some form of investigative powers? In order to achieve that, I think we're going to have the necessary debate, build a cross-party consensus, because it does implicate the Constitution and it implicates municipal government across the country. And in many parts of the country, the metropolitan police have also demonstrated real weaknesses with respect to their capacity as well as their probity. But in any event, it's not a debate that I want to close. I'm not sure that this legislation is the vehicle, but since the matter has been raised in the discussion, I'm indicating as clearly as I can what the constraints are, what my own attitude is, and what I think the approach should be. I think this matter we should try and build a cross-party consensus on what needs to be done. That consensus it's not yet in place. And that will take political debate, it will take political leadership. Now, let me come back to the question of the relationship between a legislative project and a reform project, because I think it's very important not to mix those two up. Because then I think the legislation that will emerge from the committee process will probably be unmanageable. You can't build the details of a reform agenda into a legislative instrument. For the same reasons, we don't do that with a constitution. Constitutions use general language, broad framings, which authorize further action, inter alia through legislation. And once you have legislation, further action needs to be taken in the implementation stage. Now, my approach to the reform agenda is not to wait for the Madlanga Commission finally, or even for this legislation, because certain areas we can make progress. The forensic laboratories is one example. The community policing is another example. I've already publicly indicated that I have a reset agenda which I'm working on, which I expect to be able to present to this committee in a few weeks. We're establishing a panel of our external experts in the next 2 or 3 weeks as a precursor to the establishment of the board, because I don't want to wait. I think it's very clear, following the National Planning Commission proposals, that this was long overdue. So we will establish it because we don't need a law to be able to do this. But of course, the law will help. And I think that the issues that were raised, for instance, about the composition of and functions of the board, are important questions to be addressed in thinking about what should be in this legislation, what amendments the committee might want to propose or implement in the course of carrying out its responsibilities as the committee to consider the legislation that the department is presenting. So that's another important example, I think, of how the committee can apply its mind, contribute positively to improving the legislative proposal that the department is presenting. I certainly think that the committee will also take the view, perhaps, that, well, this project started 10 years or more, just under 10 years ago, but we're in a very different moment. Does it really? Can we not take the opportunity that the committee has to say, well, in the light of the moment we're in, are there specific provisions which could be strengthened or even introduced into the legislation? Because the people who draft legislation are not fully prescient. They're not dealing with, they can't predict every fact that is going to emerge. We're now in a situation, I think, where we know more about what needs to be done, and perhaps the committee can help the department think about what should be in this legislation, even if the department, in the drafting process, the consultation process with several departments, it was they set up a multidisciplinary team that consulted over a period of time with various departments, including not just in the security cluster, but the Department of Transport and so forth. And that took time. But we're now in a different moment, and the question is, can we improve this legislation? On the question of public order policing, the issue that Honorable Khoza raised, again, I think we've got to be clear about what the law is and what the limits of the law is. Now, the Farland Commission and Constitutional Court judgments have set down the legal parameters for the exercise of force in public order situations. The right legal standards are necessity and proportionality. That's what legislation can do. Whether the police will be able, in policing public order situations, to comply with the standard is an implementation question, is a resourcing question, is a training question. And I would say that in that respect, I think we've made a lot of progress. One looks at June the 30th, in fact, there were hardly any, as far as I'm aware, hardly any injuries and certainly no fatalities. The police exercised due restraint. Some people think in situations where there ought to have been a more robust policing response. But it's certainly not my job or the committee's job with respect to second-guess the judgments that the police make in actual public order situations, except where there is a case that they have acted unlawfully. So again, the question is whether the legal standard that this legislation is attempting to give effect to following Constitutional Court judgments is the right one. I want to stress, we need to distinguish between what should be in the legislation when it comes to the reform agenda and what shouldn't be, because it's part of the implementation stage, which includes oversight. I think that once there's consensus on the legislation and it's passed and it facilitates and authorizes a reform process, the committee will be holding us to account for implementation, because I'm hoping that this process in the committee will also help us build agreement, build consensus about what needs to be done going forward for policing. And colleagues, if we get this right, if we get this right, it does have the potential to reshape policing in the decades to come. That's how important this piece of legislation is. I just make one if I may, Chairperson, respond to one matter that Mr. Khoza raised. It's very important that we can have our political disagreements, and might want to make political points in this process, but we should also get our facts right. The current head of crime intelligence is General Khoza. He's at work, busy helping us implement the organized crime strategy. And from my point of view, General Dimpane has done absolutely nothing wrong. And I don't think it's right, especially in this moment where we're trying to build something valuable, something important, to to criticize her when there's no foundation. I am responding to
No, it's
point
point
that was
of
made.
clarity. My sincere apologies, Honorable Minister. I think you are mistaking me with Honorable Shonga.
Sorry.
I
Yes,
don't think it was myself who spoke about that point.
Yeah, it was Honorable Shongwe. You're right, Honorable Khoza.
My apologies. My profound apologies. I'm on my knees, Honorable Khoza. But I also not. I mean, I do not. I think that it was a point that was made. I don't want to dwell on it. I felt I needed to stand up for the National Commissioner and just to correct the facts. But the real focus needs to be on the issues that have been raised by the members of substance on this legislation. And I will conclude by saying that I really am looking forward to a constructive process in the committee, one that will strengthen this legislation so that we co-own the reform agenda that the country needs. Thank you very much.
Thank you very much, Minister Kachalia. If I may then give the opportunity to DG Sibui for further response.
Thank you, Chair, and thanks a lot to the Minister for a comprehensive response to most of the issues that the honourable members have raised, and thanks to the questions that the honourable members have raised. The tabling of the bill was in March, Chair, and in terms of the matter that the Honourable Kolabana has raised, and that tabling, I think we had included the socio-economic report in it. But what we will do, we will re-forward or resend the socio-economic report, but maybe not just that only, that some of the questions that may require us to provide a written response, we'll just get a guidance from yourself, Chair. We will forward those written response. I think the Minister has dealt a lot in relation to the backlog on DNA. But safe to say that in terms of the 7th administration legislative program, one of the legislation that specifically deals with backlog and capacity, the DNA Forensic Act, is also part of the program, and it will in due course, after consultation has been concluded and approval by Cabinet, be also tabled by the Minister to the committee, which in actual fact also speaks to some of the issues that I think members have raised in relation to DNA matters. In relation to integrity testing and so forth, the minister have dealt with this matter, but to add to that, Chair, is that we did not want to over legislate in relation to this matter, because this is the matter which is also legislated or provided for in the Strategic Intelligence Act. Hence, at some point, there may be a need for a discussion between this committee and the Joint Standing Committee on Intelligence. Safe to say that when we consulted with the State Security Agency, consensus was that in relation to what relates to crime intelligence as well as integrity testing and so forth, we must limit it to where we have pitched it because greater details are there. But there's nothing stopping the minister from enhancing the provisions by way of regulations to say how, when, and how often, and all sorts of things, because integrity testing, you cannot prescribe it in terms of time. It must be situation triggered or a random kind of a thing. So it must allow the national commissioner and or the minister in terms of that regard. I think the functions of the NPAC minister have dealt with as well. Safe to say that NPAC it's also a matter which is provided for in the national policing policy. And that policy was approved by Cabinet in August 2025. So these provisions are also giving an effect to the whole issue of NPAC in relation to legislating it. But the functions of the NPAC are quite mirrored, or they are quite a lot. But including in the functions will also be an issue around setting standards and protocols in relation to appointment of quite senior people, including that of the National Commissioner, in terms of giving guidelines or guidance how the minister and the president should approach this matter, so that the process is more transparent, more competent, and we're able to get people that are competent in relation to that. But also around the recruitment, and I'll mirror this with the question of the chair, around issues of recruitment as well, not just only for senior people, but people that are entering the service, in relation to say those that we recruit to enter the service, what kind of people are we recruiting to enter the service? Not to recruit people that enters the service only to discover when they are already at our colleges that in terms of the integrity, the people are compromised. So those are issues that are also dealt with. I think the minister dealt with the questions that Honorable Reverend Misho has raised in relation to the use of automatic rifles. But there were issues around CPF, and especially the funding of CPF, which were also contributing to the delays, in addition to what the minister have dealt with. Around the devolution, let me not go there, because the minister, or the issues raised by Honorable Shekelen, minister dealt with those matters. The Honorable Muela, I think the issues he has raised are more of substance issues that are covered in the bill, and appreciated. I think are issues that we must note. The minimum requirements and of the NPAC as well as the binding effect of the advisories together with recommendations of CSPS and IPID. I think those are noted, which are provided for in the legislation. Issues around training, Minister have dealt with, because those are implementation issues. Minister have dealt with around the issues of delays. Minimum force. I think this legislation in relation to the training or the use of minimum force or proportional force, I think these are operational matters, and which must be dealt with in relation to how we train our POP, the capacity of our POP, and so forth, so that they are able to respond. I think there must be a differentiation between, for instance, in the issues that Reverend Misho has raised around illegal miners having been armed and demonstrators that are just demonstrating for whatever purpose that they are demonstrating on. So those are two different issues, but they are more operational in nature. I think, Chair, in a nutshell, those are issues that I've noted on my side. But with your permission, can I hand over to the team as well, starting with DDG Omar, to respond to some of the questions. DDG?
Thank you very much. Good afternoon, Chair, Honorable Chairperson, and honorable members. Good afternoon, Minister, DMs. DG, there's only one issue actually that there was a question on why CPFs were deleted from the SAPS Act. That is because there was a policy decision that it find expression, and it's now finding expression in Civilian Secretariat for Police Amendment Bill. Yeah, so that's I think the only one that wasn't answered, but otherwise I think we're good. Thank you, DG, and
thank you, Mr. Mukujane. Is there anything else?
Okay,
All right.
okay, DG, I think everything is covered except for the issue of body cams, of which we thought maybe this one is if maybe they can use the body cams in when they attend to the protests, and we thought it's not part of this bill. So it's in the regulations. Thanks, Chairperson.
All right, thank you, Chair. Chair, as per our undertaking, we will compile written responses after the Friday meeting, but based on your guidance that you will give, because some of the questions raised, they may require that we give the committee in writing for further consideration as the bill is further developed. Thank you very much, Chair. Let me hand back to the Minister. Hand back to you. Thank you.
Thank you very much, DG Sabui, and thank you for the detailed response by the Acting Minister of Police, as well as yourself and the team from the Secretariat. I just want to check with all the honourable members that there wasn't something that was missed. I understand that there are certain questions that are in significant detail, of which if you need a written response, please send it either directly, or you can work through the committee staff to send such an inquiry to get the relevant answer. Remember that we will have further engagement and opportunity for questions on Friday if need be, and I would like to also encourage the members to further scrutinize anything of the bill that was touched on today, and if there's any further input to also provide that. Remember that the committee will also have an opportunity to do our own public participation process, and all of that would still be relevant in the future, in the near future, actually. I just want to check, are there any of the honourable members that have last comment for clarity without opening the floor for a long time again? I haven't seen any new hands. If there are any questions, don't hesitate to make contact with myself, Babalwa, or Nicolette, and then we will gladly assist with that. Colleagues, I think we've reached the end of our discussion. It must be something to do with the recess that we've been able to work through the morning's agenda items at the rate in which we did. And yeah, we will see each other on Friday. I want to thank the Acting Minister of Police, DM Dr. Boshielo, DM Matale, as well as DG Sibui and the team from the Secretariat, along with all the members of the committee for joining today. Also to any other guests that we've had with us today that took part in the process. Minister Kachalia and team, thank you, and the meeting is closed.
Thank you, Chairperson.
Thank you,
Thank
Chairperson.
you, Chair.
Colleagues.
Thank you, Chair.
Thank you.